I rise to support the bill, and if you would permit me, Madam Speaker, I would like to give a very short history lesson as it relates to the matters that we are discussing today. I did not intend to do that, but some matters that have been raised by the members on the other side, I believe it's important for the nation and the members to understand the evolution of cannabis in relation to the context of this bill. In 1983, with our Constitution, we gave people the rights to privacy, freedom of conscience, and religion. In 1986, we passed a Drug Prohibition Act, which made possession and cultivation of cannabis illegal. In 1994, we became party to the 1961 Single Convention on Narcotic Drugs, which provides that parties shall take such legislative and administrative measures as may be necessary to limit exclusively to medical and scientific purposes the production, manufacture, export, import, distribution of, trade in, use, and possession of cannabis, among other drugs. Having joined the treaty in 1994, St. Kitts and Nevis is bound to comply. In summary, St. Kitts and Nevis has, by acceding to the 1961 Convention and the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances of 1988, which was acceded to in April 1995 by the Federation, have undertaken to criminalize the possession, use, cultivation, and trade in cannabis and cannabis resin, except for medicinal and scientific purposes. What happened since then, Madam Speaker, is that in 2017, the Cannabis Commission was set up to consult with the public, conduct research, and prepare a report to the government as to what we should be doing in relation to cannabis. That report was delivered in January 2019 and made certain unanimous recommendations and certain other recommendations which were not unanimous. Subsequent to that report, in May 2019, the High Court in the Rasta and Kofa case that has been spoken about declared, as has been indicated by the member for number 8 earlier, that it is a breach of a person's constitutional right in St. Kitts and Nevis to be prevented from possessing any amount of cannabis, to be prevented from cultivating any amount of cannabis, and for using and cultivating cannabis for religious purposes. What that did is that set the trajectory that we're on now, because when a category of crime is declared unconstitutional, as the court did in May 9, 2019, it said, the judge said, I will delay the effect of my striking down of the cultivation provision and the possession provision and give Parliament 90 days to rectify this. What Parliament did in those 90 days, I believe in August 2019, is that they then decriminalized possession and said if you possess, well, they intended to say if you possess 56 grams or less of cannabis and 15 grams or less of cannabis resin. Resin is the byproduct, where the THC, the psychotropic elements are concentrated, whereas cannabis is the plant and the product of the plant. So they addressed the possession part. You could get a ticket if you possess less than that. Above that, it's still a criminal offense. They sought, and when I say they, I mean this Honourable House, sought to rectify the cultivation aspect. And they created a provision which said, I crave your indulgence, Madam Speaker, I had it right here. It said that you need to apply to the National Drug Council for a permit to cultivate. In fast forward now, so this is August 2019, fast forward now to February 2020. What this Honourable House did was it passed the Cannabis Act, the Cannabis Act really sets up the regime for a medical cannabis authority and for the cultivation, sale, etc. of cannabis for medicinal purposes. In that same sitting, and I believe this is why the learned member for number 5 mentioned this a disjointed approach. In that sitting, what they did was they removed the cultivation section, the application to the National Drug Council, and they left it blank. But what they did not do is they did not enforce the licensing mechanisms within the Cannabis Act. So what we had effective February 2020 is that this Honourable House did not address the constitutional right recognized in May 2019 with respect to cultivation. I do not know why that was done that way, but it was not addressed. Possession was addressed. The Criminal Records Amendment Act was passed similarly in February 2020, and that cleaned the records of persons who were in possession of small amounts of cannabis. What we are trying to do is rectify that issue with respect to cultivation. And we're not doing it just by this piece of legislation. We are also in the final stages of presenting to this Honourable House amendment to the Drugs Act, which will also reflect the decisions that were made in the Rasa and Kofa case, as well as amending the Cannabis Act to allow for the Medicinal Cannabis Authority to have the power to now actually regulate the industry. So this is the first step in that three-pronged process of bringing the industry, the medical cannabis industry, which does not breach our international obligations, into St. Kitts and Nevis. But this particular piece of legislation, I want to clarify that. This piece of legislation, as acknowledged by the member from number 7, is filling the gap that was recognized by the court and recognized by the Cannabis Commission, that if you are moving forward by allowing possession of a certain amount, cultivation of a certain amount, licensing to farmers to produce medical marijuana, allowing Rastafarians to practice the sacrament of smoking cannabis within their religious groups, then you must also address the injustices that happened in the past. And this very, very, very simple amendment from a legal perspective is just filling that gap. The original amendment in 2022 said, if you were convicted of cannabis, convicted of possession of cannabis of a certain amount, or you were convicted of possession of cannabis and your sentence was a certain amount, or you were fined, then your record is expunged. All this piece of legislation that has been tabled is doing is seeking to say, if you cultivated 5 or less trees and you were convicted, your record could be expunged. If you were convicted of cultivating any amount of trees and the sentence was a fine or imprisonment of 3 years or less, your record is expunged. And this is in keeping with the constitutional rights that were recognized in the Sankofa case. So even more so than the commission report, which predated the decision in the Sankofa case, it would have been good if we had a subsequent report considering the serious declarations in the Sankofa case subsequent to the report. Then the committee could have examined and said, well, now we have another declaration, or the only declaration as to where cannabis possession and cultivation stand, whether it's for private use, for religious use, or the other term is privacy, oh yes, and freedom of conscience. What we are seeking to do is the first step in rectifying that constitutional lacuna. And that is all that is being done. I also want to make it clear There is no 5-3 legislation in St. Kitts and Nevis. I know that the reason why there is so much confusion with the police is that what was said to be done, what the commission said should be done, was never done. And I'm not going to say what the consequences of that lacuna are, but I can tell you, whether it be the next sitting on the 22nd or the one shortly after that, we are going to rectify that issue by way of an amendment to the Drugs Act, which we're going to table and have a debate on. And the only element that we are waiting on in order to present that is the current statistics from the National Drug Council, which we now have. There is absolutely no law in St. Kitts and Nevis at the moment which restricts cultivation. That is the honest truth. And we're going to rectify that very shortly. This is not encouraging anyone to do anything. This is just, I don't want to say terms that I'm very familiar with, like negligence or lack of attention to detail, but it should have been done, and we're going to make sure that it's done so that after those 3 pieces of legislation are amended, everyone will be clear as to what you can and cannot do with respect to cannabis. If you're in the privacy of your own home, you can participate in use of cannabis. If you want to cultivate 5 trees in the 5 or 7, whatever the parliament decides in terms of number, you want to cultivate for your own use in your private yard, that will be brought. If you are a member of the Rastafari movement, they've told me don't call it a religion, the movement, then, and you apply for a license to declare that you have a religious place, which is contemplated by the Cannabis Act, you will allow to participate. If you get a license from the Medical Cannabis Authority to grow marijuana, to be able to sell it for medicinal use, you will get a license to do that. And there will be clear delineation and clear law as to what you can and cannot do. That clarity is coming very soon. This, however, piece of legislation is the first step. It is rectifying some of the wrongs of the past and clarifying what should have been done subsequent to the RAS and COFA decision in May 2019. So with all that said, Madam Speaker, I wish to support the bill. I think it's a very important bill, particularly for that reason. We have to close these constitutional loopholes that currently exist with our legislation as it relates to cannabis. And this is the first step. The next steps are coming very shortly. If it pleases you, Madam Speaker.